So I personally love winging things. I think it's really fun, but there's a time and a place for it. And when you're working in a law firm under lots of pressure and you have a client waiting, that is not the time to wing anything. So here's the therapy part of research the law. It's going to be very normal for you to have thoughts and feelings along these lines here, especially like, am I committing malpractice? Is this the right law? The whole point of research law is to teach you a method to overcome those things. So our Google world has taught us that we can just throw in some search terms and find things. And that works if like you're on Amazon looking for an Orrery or some other Christmas present. But if we throw in our search terms for our hearing loss issue, we're largely going to get law firms because Google's biased toward those who pay them money to put their links up top in the research hits. So Google's not going to really help us that much for researching the law. And then if we throw them into Lexis here, we're going to get lots of different stuff as well. You can see here just tons of stuff, but it's like we're an archaeologist at this point, and there's all these little shards of the law everywhere, and we have to piece them together, just like an archaeologist finds a little shard of pottery here, a little shard of pottery there, and then they spend hours and hours and hours, if not weeks, piecing these pieces together. Well, that's ridiculous. We don't need to do that as researchers. Instead, we can follow a methodical plan and save a lot of time. So in step one, we'll frame our issue, which at the beginning will be whether our client can recover pain and suffering for the auto accident. And then we'll go into secondary authority, step two, and find a really great ICL treatise. And this ICL treatise basically does all the research for us. Okay, it does all the research for us, not all, but 95% of it. So the treatise here taught us about the codified law. It told us about the main statutes, the main case law. It sorts out difficult periods of time. Like if you find anything during the Kreiner period that is likely going to be reversed and overruled, you can't use it. The treatise told us about that. So after doing step two here, then we can go back and refine our issue. So now it's going to be whether losing your hearing and the amount that he lost was a serious impairment. All right, and then in step three, we'll take the codified law from step two, which is 3135 of our compiled laws, our statutes for Michigan, and then we'll make sure that we're not missing anything. And then we'll go into step four of the research process, which is where we look for case law. And we already found the main case from our treatise in step two, so we'll research that more fully and do some additional research. And that led to this Moore versus Kruger, which is where somebody had a detached retina. So partial loss of sight in Moore versus Kruger led to a recovery. So we can analogize to partial loss of hearing. Now, we'd use a couple other cases probably, but for purposes of this scale 1.2, winging it, this is enough to illustrate our point that you need a plan. Okay? All right, see you back in the workbook.